In the case of common law couples, how is property divided? Are the rules the same as for legally married couples?
In Ontario, couples who are not married or are living as common law can apply for their properties to be divided when they separate from each other. The law and the process for them is different from a married couple and can get quite complex because the couples may have to provide extensive accounting evidence of which of them did what and who paid for what during their common law relationship. This accounting exercise can go back 10 to 20 years. It is difficult to determine the intent of the couple regarding the purchase and sharing of property many years after the relationship has begun. Typical example, a common law couple has lived together for 10 years. A house is in one partner's name. The other partner gave up employment during the relationship to raise the couple's children and to supervise and participate in home renovations. Although the home is only in one partner's name, the other partner may claim an interest in it or monetary compensation as a result of his or her contributions to the family and the property. In other words, the home is considered to be what is called a joint family venture. In the event of a dispute, the court will have to decide whether a piece of property or the value of property was obtained as a result of a joint family venture. In determining whether or not a joint family venture exists, the following factors will be considered, although not exhaustive. Mutual efforts. Have the parties worked together towards a common goal? This may include consideration of the pooling of efforts and teamwork, decisions to raise children together, and the length of the relationship. Economic integration. The more extensive the integration of the couple's finances, economic interests, and economic well-being, the more likely it is that they should be considered as having been involved in a common or a joint family venture. Actual intent. Did the parties intend to form a joint family venture? These intentions may be shared, stated, or inferred by the parties' actions. Did the parties hold themselves out as being equivalent to married to others? Was the relationship long and stable? Another factor to consider is the priority of the family. Did the parties plan for their financial future together? Did one party give up his or her employment for the common financial future of the family, including children? Is one party left in a worse position than he or she otherwise would have been if he or she had not acted in a way to assist the family to his or her financial detriment? Mutual benefit conferral. The respective contributions of the parties are taken into account in determining the claimant's proportionate share. However, the weighing of benefits is not an exact science. It calls for the reasoned exercise of judgment in light of all the circumstances and the evidence. Benefits are not necessarily monetary. Labor, time raising the children are also important factors. Once the court determines that there is a joint family venture, courts will then decide on the appropriate remedy. Courts have significant discretion in terms of the appropriate remedy. For instance, if a percentage interest in the joint family venture is awarded to a common law spouse, such percentage may be anywhere from 1 to 100%, depending on the evidence and the particular circumstances of the case. Alternatively, the court may award that monetary compensation is sufficient instead of giving an ownership interest in the property.